Hello, my name is Glenn Hinkle. I'm a tax lawyer in Haddonfield, New Jersey. I'm with the law firm Kulzer and DiPadova. I'm here with my partner, Art DiPadova. We're going to discuss the estate tax rules that have gone into effect over the past several months. Today is March 12, 2010, and really the discussion today is going to center on some of the things that have happened late 2009, early 2010 that may affect estate planning. A lot of this created a genesis of a 2001 law. Art, what was that all about?
Well, in 2001, Congress passed a Tax Reduction Act that reduced income tax rates and also made changes to the federal estate tax rates by increasing the credit or the amount that could be left to other than a spouse or charity without estate taxes. And it went from a relatively low amount of $675,000 in 2001, and last year in 2009 it had increased to $3.5 million. That means each spouse or each person could leave up to $3.5 million other than to a spouse or charity without any federal estate taxes. Now, under the 2001 law, the estate tax is entirely repealed this year, effectively an unlimited exemption. But then in 2011, the entire 2001 Act is repealed, and we go back to the old rules, which at that point was a $1 million exemption each, which is the lowest number that we've had since probably 2003 or 2004.
So in effect what we have is a rule that says that you can leave unlimited amounts to your spouse, unlimited amounts to your charity, and anything's going to be taxed over the exemption amount. And in 2009 the exemption was $3.5 million. A lot of our clients have used that $3.5 million exemption or lower when it was $2 million or $1.5 million, so that the children could inherit from mom and from dad and essentially double that amount. One of the things that we've had here in New Jersey is that New Jersey has an estate tax. It imposes the tax at a lower exemption threshold of only $675,000. However, the rate of tax in New Jersey is a lot lower than the federal estate tax rate. When the federal estate tax rate applies, it's a fairly healthy charge. So, at the end of 2009, many of our peers expected that Congress would freeze the estate tax. It had been in the Obama budget proposal. There had been a number of bills before Congress. The expectation was that the law would be imposed permanently with a $3.5 million per person exemption. Unfortunately, Congress got distracted at the end of 2009, and they haven't really refocused on it in 2010. So as we sit here today, we're in a limbo land where there is no federal estate tax in 2010, but an expectation, if the law does not change, that we'll go back to a $1 million per person exemption in 2011. Art, what do you think might happen?
Well, that makes the challenge, the planning a little challenging right now. It's the fact that Congress can do something in 2010 and impose an estate tax. They could do that next week, next month. They could make it retroactive to the beginning of the year. Kind of don't know what the rule is going to be in 2010. Congress might yet make the federal estate tax as it existed in 2009 permanent with the $3.5 million exemption, or Congress may do nothing and we go back down to the $1 million exemption. So we really don't know, and we need kind of a flexible estate plan to deal with that.
Wow, that's kind of crazy. They can pass a law today that's going to impose a tax on somebody who's already passed away?
Well, you know, we've had an estate tax for 90 years, so it's not a new tax. There is likely to be a challenge on constitutional grounds, but if there is, you're certainly not going to know the result of that for many years. So.
Of course, getting out of an estate tax means that someone has to pass away, so it's certainly not something that somebody's going to be looking forward to doing. But if someone did pass away in 2009, the rules really aren't that great, because while there might be no estate tax, Congress implemented a new income tax rule in 2001 that was to be effective this year, which says that in the event that a person passes away, there might be a gain on the sale of some of the assets. Historically, we had a rule called step-up in income tax basis, which was a way of more or less eliminating any gain on property that would be sold by an estate. Now, going forward, those rules are going to be a little bit more complicated. Congress also did something with the generation skipping transfer tax. Now, if you know anything about the generation skipping transfer tax, you know that it's a little bit more advanced, a more complicated rule, but that was also repealed as part of the 2001 law. And it also made some other interesting rules regarding gifting. Some clients get involved in gifting plans as a way of minimizing the tax, and now we have new rules related to gifting. What do you think clients should do, Art?
Well, most people want to know, now that we're in this area of no estate tax. Do I need to change my will? Do I need to do something? For the most part, the wills that we have done at our firm anyway have been flexible, designed to accommodate whatever the estate tax credit is, or even to deal with the fact that there is no estate tax. So generally, it's unlikely that a person would have to change the will for tax purposes to cover the eventuality that somebody might die in 2010, because again, this exemption is only for 2010, the lack of estate tax.
So you don't think that we need to address any immediate changes except in the rare circumstance?
I think that's correct, that's right. But that doesn't mean people shouldn't consider reviewing their wills and asset ownership, right?
Yeah, I mean, certainly estate planning is nothing more than a plan, a process to get your assets to your heirs with the least amount of aggravation and stress. And so usually the rule is that property will pass first to a surviving joint tenant by operation of law, or second by a contract beneficiary designation like an IRA beneficiary or a life insurance beneficiary. And certainly part of the plan is going to involve looking at how those assets are held, how those assets are titled, and how they might pass in the event that a person were to pass away. For a lot of our New Jersey clients, we've used trusts historically to minimize the New Jersey tax. Relatively the same rule applies in Pennsylvania. Pennsylvania does not have an estate tax, but they have an inheritance tax, which is going to impose a tax at the death of an individual. So the main reason that clients might want to get together to review things is to consider their fiduciary choices. Art, what's a fiduciary?
Well, the fiduciaries are the executors, trustees of trusts for children or grandchildren, and this is probably one of the most common changes that people make to their wills over the years. Not necessarily changing the dispositive scheme of the tax provisions, but who's going to be my executor, who's going to be the trustees. As children grow older, they're often put in these roles because they're more mature now, and that is certainly one good reason to take a look at the will and maybe come in and sit down and have a meeting to go over it. And the second thing, as you mentioned, is asset ownership. You know, asset ownership does have an impact on the ability to use some of these tax credits, and that tends to migrate over a period of years. So that's also a good idea to review periodically.
So in a nutshell, we don't think our clients are going to need to immediately look at their estate plan for tax provisions, tax changes. There might be a circumstance for wills that were done more than, say, 10 years ago before the 2001 law was passed that you might want to look at the dispositive terms. But by and large, we don't think many of our clients are going to need to adopt any changes unless other circumstances warrant, like change of fiduciary, titling of assets, things like that. We hope that this has been instructive for you. Hopefully it will allow you to meet with your other family members, whether it's meeting with a trusted advisor like your CPA or your financial professional. But if you'd like to meet with us, we're certainly willing and happy to do so. Thank you for taking the time to spend a few minutes with us today, and we hope that this has been instructive.